Imagine a high-stakes battle unfolding in the world of sports, where the future of a legendary coach hangs in the balance. The Nevada Supreme Court has just handed Jon Gruden a significant victory in his ongoing legal saga against the NFL. But here's where it gets controversial. This decision could set a precedent that challenges the league's long-standing practice of resolving disputes through arbitration. Back in November 2021, Gruden filed a lawsuit against the NFL and Commissioner Roger Goodell, alleging that they had used leaked emails to publicly sabotage his career and force his resignation from the Las Vegas Raiders. This lawsuit has been a roller coaster ride ever since, with the fate of the case swinging back and forth between different courts. Last year, a 3-judge panel of the Nevada Supreme Court ruled that the case should go to NFL arbitration, citing an arbitration clause in Gruden's contract. However, Gruden's supporters weren't giving up so easily.
They fought back, and in a stunning turn of events, the full court overturned the panel's decision with a 5-2 majority. This means that Gruden's lawsuit will now be heard in a courtroom, potentially opening up a new avenue for justice. The NFL has the option to appeal this decision to the U.S. Supreme Court, but they haven't commented on it yet. For Gruden's legal team, this is a major victory. As attorney Adam Hosmer-Henner of McDonald Carano stated, "We're very pleased with the Nevada Supreme Court's decision, not just for Coach Gruden, but for all employees facing an employer's unfair arbitration process." The court's reasoning behind their decision is both intriguing and complex. They concluded that the arbitration clause in the NFL Constitution is unconscionable and doesn't apply to Gruden as a former employee. Additionally, the court found that the NFL couldn't use equitable estoppel to enforce the arbitration clause in Gruden's coaching contract with the Raiders. In simpler terms, this means that the league can't force Gruden to go through their preferred method of dispute resolution. It's worth noting that 2 of the judges dissented from this decision. Justice Christina Pickering, joined by Justice Alyssa F. Kaddish, argued that Gruden agreed to the arbitration clause in the NFL Constitution and should be bound by it. This split decision highlights the contentious nature of the case and suggests that there might be more legal battles ahead. Gruden's lawsuit goes beyond just personal grievances. It touches on broader issues of fairness and accountability in professional sports. His attorneys argue that the NFL and Goodell engaged in what they call Soviet-style character assassination, using leaked emails to tarnish Gruden's reputation and career. These emails, which contained racist, homophobic, and misogynistic language, were sent over a 7-year period while Gruden worked for ESPN and were later gathered as part of an NFL investigation. The NFL has vehemently denied leaking the emails, stating that Gruden should bear the responsibility for any consequences. Former team owner Daniel Snyder and his wife, Tanya, also denied involvement in the leak during a league meeting in 2021. Despite these denials, the controversy surrounding the emails has lingered, adding another layer of complexity to Gruden's case. So, what does this all mean for Jon Gruden and the future of NFL arbitrations? Only time will tell. This decision by the Nevada Supreme Court could lead to significant changes in how disputes are handled in professional sports. Will other athletes and coaches follow Gruden's lead and challenge arbitration clauses in their contracts? Or will the NFL succeed in appealing the decision and maintaining the status quo? As we watch this story unfold, it's clear that the lines between fairness, accountability, and the rights of employees in professional sports are being redrawn. What do you think? Should the NFL be allowed to enforce arbitration clauses in cases like Gruden's, or do employees have the right to seek justice through the courts? Share your thoughts in the comments below.